two preliminary points of law where we requested invited you to submit to the court, and that is whether the applicant has locus standi to bring the issues at hand before this court, and whether the Supreme Court has the jurisdiction to hear the matter. We had earlier on studied the submissions of the applicant, and during our recess we had the opportunity to study what was filed on ECMIS by the respondents. We also considered the oral submissions in court by the respondents, as well as the oral submissions or reply by the applicant in court. The court has arrived at a unanimous decision, and I invite my learned brother, Justice Isama Madrama, to deliver the decision of the court. But a more detailed ruling will be uploaded on ECMIS later. So, my Lord,
thank you, my Lord. This is the short ruling of the court. We have considered the oral and written submissions of the parties and the pleadings. The question that we sought the parties to answer is whether the applicant has locus standi to invoke the original jurisdiction of the Supreme Court, and whether the Supreme Court has jurisdiction to hear and determine the application. This was stated in questions: does the petitioner have the right to appear? 2, does the court have the power to hear the pre-election dispute? 3, does the court have the power to grant a prohibitory injunction against the carrying out of a constitutional process? On locus standi, Article 104 of the Constitution is narrowly construed. It provides for a petition by an aggrieved party who must have been a competitor or candidate. It has to be a post-election matter after a declaration of results. The orders that an aggrieved party may petition for are statutory. The word aggrieved party is exclusively construed. Post-election matters are time-bound. Orders to be made are statutory, such as nullification of elections after they are heard in a time-bound petition, declaration of a winner, or ordering re-election. The applicant does not qualify to be an amicus curiae of this court, as he has not been admitted and there is no pending matter before the court. The applicant's application for leave to be a friend of court is improperly before the court, as it doubles as a party. The applicant should be a neutral party. Further, this court is restricted under Article 104 of the Constitution to make orders that are statutory. Coming to the subject matter jurisdiction, does the court have the power to hear pre-election disputes? The Constitution, Article 132 of the Constitution, establishes the court primarily as an appellate court, the final arbiter of appeals from the Court of Appeal. The primary role of the Supreme Court under Article 132, Clause 2 and Clause 3 is to hear appeals. It follows that the exercise of original jurisdiction is an exception. The only original jurisdiction the Supreme Court possesses is that conferred by Article 104 regarding presidential elections. This has created a rigid jurisdictional binary. If a matter is a presidential election petition filed by a candidate, the Supreme Court has original jurisdiction and final jurisdiction in the matter. If the matter is anything else, including a pre-election dispute filed by a voter, the Supreme Court can only hear it in the exercise of any prescribed appellate jurisdiction, if any. The applicant's application is not a pre-election matter, and the Supreme Court enjoys appellate jurisdiction. The applicant's matter is a pre-election matter. Sorry for that. and the Supreme Court enjoys appellate jurisdiction under Article 132 and cannot sit in an original matter for matters that do not fall under Article 104 and Section 61 of the Presidential Elections Act. The scope of the Electoral Commission mandate includes handling complaints regarding nominations, academic qualifications, campaign irregularities, and voter register issues. A person, including a non-candidate stroke voter, aggrieved by pre-polling irregularity can file a complaint with the Electoral Commission. If a party is dissatisfied with the Electoral Commission's decision by pre-polling complaint, the recourse is not to the Supreme Court. Under Section 15, subsection 2 of the Electoral Commission Act, a decision of the Commission may be appealed to the High Court. To injunct a constitutional process where the specific relief sought, an injunction to bar the holding of election, places the petition squarely in the specific relief sought, an injunction to bar the holding of election, places the petition squarely in the pre-election phase. There is, however, a constitutional command to hold elections under Article 62, Clause 2 of the Constitution. Article 61, Clause 2 of the Constitution. Article 61, Clause 2 of the Constitution commands the Electoral Commission to hold presidential elections within the first 30 days of the last 122 days before the expiry of the term. This is a mandatory constitutional duty. It follows that a court cannot order barring the election. It follows that a court order barring the election would essentially order the Electoral Commission to violate Article 61, Clause 2. Courts generally have no jurisdiction to issue injunctions that compel the violation of the Constitution. The third respondent is a sitting president of the Republic of Uganda who enjoys presidential immunity in office under the Constitution. In the premises, he is improperly sued. Orders. We strike out the proceedings against the third respondent. The applicant's application is dismissed with no order as to cost. The court will upload its detailed ruling on ECBIS, delivered at Kampala this 12th day of January 2026.
There was an application that was filed in the court for various orders, but I think the most important part was to try and stay the conduct of these elections, which are supposed to be held on the 15th. We argued the application this morning and opposed the application on the grounds that the orders that were being sought could not be constitutionally granted by the Supreme Court, and the Supreme Court did not have original jurisdiction to hear pre-election disputes of any nature. The court rendered this ruling this morning and agreed with the submissions of the respondents, that is the Attorney General and the Counsel for President Museveni, that indeed the Supreme Court does not have the jurisdiction to hear original matters in election disputes, and the only original jurisdiction that it has is to hear a post-election dispute in case one arises. It also dismissed the application in the instance of Counsel for President Museveni, that as a sitting president, you do not have the jurisdiction to bring him to court. Struck out on that ground. Because the government has not, recommendations that were given by the were not implemented. A number of amendments were made to the electoral laws, and in compliance with the guidance of the recommendations of the Supreme Court. Then, obviously, there are recommendations from the Supreme Court, and the government then goes and looks at them and implements them in accordance with the legal framework that exists at the time, and that was done. In fact, in 2019, they came back to court at the time to report on it, and it was done. In 2021, we had an election, and as you may remember, there was an election petition in 2021. The court did not at any point raise that the recommendations that were given then had not been complied. Everything was complied with.
Attorney General, there was an issue of electing the chairman of the Electoral Commission, that the people should be participating in an election of the Attorney General.
No, that was not in the court. It can't even be given because the courts don't. The Constitution tells you how the Electoral Commission is instituted, and we cannot just simply ignore the constitution. But if the people of Uganda want to choose otherwise, then you go to the constitution and have the amendment done there. The court didn't make such an order. Uganda yaso musango emirizo okulonda kwa 15 January ngera agamba court nti alina ebintu bingi ebitamusanyusiza ekisingira ddala kuba nti waliwo ebintu court byeyalambika byeyawaako ensala mu 2016 ebadde tebinabakolebwa. Tuze mu court netubategeeza netuwoza mu court nti no court teyinza kukola kintu ekyo kubanga obuyinza tebulina obutuula mu musango nga omukulu ogwo yabadde aleese. Era court nekiriziganya naffe nti tebalina buyinza butuula mu nsonga eyo. Bw'aba alina ensonga yonna ekwatagana n'ebyokulonda abitwale mu Electoral Commission, agende mu High Court oba anaakomawo wano in form of an appeal bw'aba nga ajulidde singa omusango gubeera nga ensala temusanyusiza mu kooti ezaawo. Yali emugulumya ebintu yagamba mune ebintu court byeyawaako endowooza mu 2016 tebyatuukirizibwa. Naye tumugamba nti ekyo si kituufu kuba ebyo byonna court byeyayogerako byakolebwa era Attorney General agenda naye era twagenda mu kulonda mu 2021 era mu 2021 bajja mu court wano era court teyemulugunyako nti ebintu byonna byeyali eyogedde tebyakolebwa n'olwekyo court negoba omusango.
Honorable, emirundi mingi tulabye
kati omuwabi wa namba 3 omukulu yabadde awabidde Attorney General Electoral Commission ne President Museveni. Bapulida ba President Museveni bawozezza ne bategeeza court nti President Museveni ng'akyali president atudde mu ntebe omuntu yenna takkirizibwa kumuleeta mu court ku nsonga yonna okuggyako ng'omuleese wano singa ebeera nsonga ya election petition. Court nekkiriziganya naye era omusango ogwabadde guleeteddwa ku President Museveni bwetyo court negugoba.
naffe kooti eno gukwatagana ku ki era kiki kyoyagala kooti eno ensukkulumu ekole ku musango gwe wataddeyo? Tandika namanya.
Amanya Mukisa Patrick muna Uganda wawulijja emyaka nkona kyanjawulo. Musango gwe natadde mu kooti ng'asabye kooti ensukkulumu emiriza okulonda okubinda olw'ensonga nti kuli mu bukyamu kubanga ekooti eno yennyini yonna ebiragiro byeyalagira gavumenti ekole nga tebannaba okulonda kwonna. Emyaka 10 egiyise naye tebabikola bye bagenda mu maaso n'okutegeka okulonda buli bbanga.
Ebiragiro ki ebyo bye kooti ensukkulumu bye yagamba era bye balemesezza otteeka mu nkola paka nakati?
Ebiragiro mulimu ekyokujja abakozi ba gavumenti abantu bana bafuna essente okuva ku mirimu w'omusolo kuva mu byobufuzi by'eggwanga. Ekyo kooti yakiragira. Neyagira amagye gave mu kulonda. Neyagira tekinologi yaba akozesebwa era amateeka agafuga tekinologi oyo galeetebwe ng'ebula emyaka 3 okulonda kubeewo abantu basobole okuyigirizibwa okutendekebwa obulungi. Ebirala ebyalimu mwalimu media ogambye nti oliwa UBC radio UBC TV flooded with Museveni's campaign. Wonna New Vision ku front page oyinza okuta nti so media abamu kijagamba nti gundi agikozesa buli lunaku naye mukitegeera nti bagikozeseza government media. Bw'okujjako government media nene ya private aba private tebatebakirizibwa. Last elections bagoba Facebook up to now. In fact nakiteddemu nsaba kooti esazireemu ekyo kye bakola mukifo kyokuleeta reforms bagoba private media. Internet bagijjako nga balinga batalina mateeka. So ate kooti yagamba wabeewo amateeka agende mu buwandiike gayigizibwe n'abantu ng'ekyabula emyaka 3 n'ebirala bingi tubimala.
Kati oyagala kooti eno ekole ki?
Kooti eno okulonda eragire ebiragiro byayo byonna bimala okuteekebwa mu nkola. Baddewo okulonda.
Mu nnaku zino entono ezisigaddeyo naku nga 2 tugende mu kulonda
sintono kubanga mu nsi ezimu basazizaamu kati singa bakusazaamu okyaliruuti kubanga oli asobola okudduka mu kooti n'agamba nti nno ebiragiro bye baakuwa ekyo ndowooza ekyokuyimiriza kiri kiipa than okusazaamu nga mumaze okulangirirwa n'okukola patina bikibi
nga gwe munnayuganda agoberera enkola enfuga y'amateeka ebiragiro kooti bye ziwa naddala ne kooti ensukkulumu ne kooti endala obutateekebwa mu nkola kikosa kitya enfuga ya demokrasiya n'engeri akakiiko k'ebyokulonda gye kakolamu emirimu gyako?
tufuna buzibu bungi nnyo. Mu petition yange nasabye gavumenti yalondebwa mu 2021 esazibwemu byonna bisazibwemu n'abantu babadde bavunaana emisango babadde kubanga tebalondebwa mu butuufu balondebwa nga bamenya amateeka mu ngeri enyangu kiyinza okugamba beewaŋŋamya. So kufuna ebizibu bifaananga byolaba kuba bantu kola ki kutta ebizibu bingi tosobola kufuna ggwanga litambula bulungi. Tuyinza okwesanga tufunye Libya oba Venezuela.
Mu bbanga lino ezisigaddeyo n'ensala ya kooti kiki ky'oyinza osuubira? Lwaki omusango guleese kikeerezi ng'ate ensala baazikola dde okuva mu Mama Mbabazi Besigye ne oguno ogwakamaliriza ogwa Bobi Wine? Lwaki ensonga zo zireese kati?
Ogwa Bobi Wine yaguggyayo.
Okay, ya Mama Mbabazi ne Besigye lwaki ensonga zo zireese kati ng'ensala baazikola dda 2016, 2021 n'endala ne 2016.
Illegality. Obumenyi w'amateeka tebuliko. Bw'okwata omuntu eyakubba ekintu mu myaka 20 nga nti lwaki wamukutte leero nze nakategeera kubanga saali pati nakabitegeera era we nategeeredde we natandikidde ninsuubira nti ekkooti ejja kumpa orders.
Bubaka ki bwa akakiiko k'ebyokulonda mu kiseera kino kubigiragirwa okukolebwa naye nga tebiteeka mu nkola?
Mu kakiiko k'okulonda ako we nali nkawaabira nasaba kukawaabira bammemba baako bawaabira omuntu mu buntu bya Mukama ani bonna commissioners bavunaanibwe ng'abantu so singa naye ekimbagamba bibalemye bakolera kontroli za muntu omu bwemu n'ebirala ebinyumya abesinga kubuulira olibo ndabyo byalimu.
Okay, amanyi ogambye gwani?
Kisa Patrick.